We are live. Welcome to the Listen to This Bull live show on a special day. It's Thursday. We normally do this on Tuesdays. My name is Matt Mulholland. That's Tim Johnson. He's my guest for today. I pull him on afterwards. I forgot to kick him off. If you have never seen this show before, this show is driven by the audience. If you're watching this live, you have the great honor of being able to put some comments and questions into whatever source you're following this or watching this at. If you're listening to this on a podcast, it's too late for you. Sorry, you should watch this thing live. It's a lot better because you can actually drive the conversation. We can answer your questions. Before I get started and introduce Tim fully, I've got to hit this button. Tim Johnson. I said that kind of like Matt Damon, just one of those weird things.
Please don't get that started. I don't need that in my life.
Let's not do that again. I want to say it again suddenly. I don't know why. Tim, you're an attorney in several states. One of the smarter attorneys that I've come across and highly recommended by people that I trust quite a bit. I've never used you myself, though, but can you give a little bit of your background to everybody?
Sure, of course. So my firm is Smith, Jaden Johnson. We have offices all over the Midwest. We're predominantly in, the North and Upper Midwest. So we have offices all the way from Denver to Columbus, Ohio, and basically we operate everywhere in between. And the predominant work that we do is helping policyholders when their claims aren't getting paid, no different than many people on this podcast. We also do a fair bit of construction law and we do some other things. But for the purpose of this podcast, the predominant thing that we're focused on is helping policyholders recover when their insurance companies are denying or underpaying the claim.
Right. So we're going to talk about something that you don't necessarily deal with professionally, but you are one of the smarter guys on this. We're going to talk about public adjuster contracts. Do you handle writing those for people?
I've written a couple as favors. It's not like a predominant area of practice. Depending on the state you're in, like in Minnesota, they're pretty easy to write. In some states, Florida's and Texas and some others, where there's more heavy regulation, you probably want somebody that actually specializes in it. But I've dabbled. I've written a couple.
You've dabbled. All right. So there are attorneys out there that really focus on this kind of a thing. Holly Soffer is one of those attorneys that really focuses on this, and that's kind of her primary duty. So I would recommend getting a hold of someone like that. If there is a question, April says, "Hey, Tim," and then says, "Oh yeah. And Matt too."
Hey, April.
Richard asked if you work in Illinois.
We do.
You do. Thank God, dude. It's hard to find someone in Illinois.
There's a couple of good ones, but I'll keep the referral to myself for right now.
Yeah, there you go. So we're going to talk about public adjuster contracts. I've recently come across one that has made some rounds in Florida. I'm not really sure where it comes from. It's very generic. It doesn't even have a name on it. But a few people have sent this to me over the years, and it's ugly. It is a Florida contract, and I know that you're not a Florida guy. So, but what I want to do is point out some real obvious flaws in this thing and some things that are very concerning and try to talk about this in a very generalized, not state specific way. So ignore the fact that this is Florida and let's just talk about contracts in general. Does that work out?
Yeah, we can set the stage for that because most states contract law is the same. And from an overview point, the contract is going to need to be in clear and definite terms. And it's going to need to have an offer and an acceptance, meaning I offer to do something for you. In exchange, you offer to pay me. And there's got to be that consideration, in which case the payment. So for a general purpose, the contract law is basically the same in every state. So why don't you bring it up and show me what you're looking at?
Yeah. If you guys are listening to this on a podcast and don't have the pleasure of being able to see this one, I would recommend you find a way to actually watch this one as well. There's going to be some things up on the screen. I'm going to read it out loud, but it'll be a lot easier for you to follow along if you're actually watching us this time. So if you're doing this on podcast, you're not as cool as everybody else. All right. This is the contract that I've gotten a few different times. It is very generic. I don't know where this came from. But if you have found this and are utilizing this contract, there are some concerning things that are on here. I want to point them out. But let's start at the top. A lot of those states require the name of the contract to be very specific. Usually it has to be public adjuster contract or something in some kind of special type, right?
Usually.
So this one does say that. And I think it's probably a 12-point font, which is probably the minimum requirement, I think, for any of the states that I've seen. But then it goes on to say, and it's a preliminary proof of loss. I've never seen that on any contract before.
I haven't either. And typically, and in the insurance world, proof of loss is a pretty specific document. So we would typically see that accompanied with an estimate or supporting documentation for your loss. But I don't believe that I've ever seen a public adjuster or any other kind of contract be married to that form. I can't think of why you'd want them together, but I can think of a lot of reasons why you would want them separate.
Yeah, me too. Now, I know that there are some states where there's some case law that basically could make almost anything a valid proof of loss sufficient to pay a claim, but that doesn't make everything an official proof of loss coming from a public adjuster.
Sure.
So I'm not so thrilled with this being on the same form, and it does get confusing because it contradicts itself anyway as we move further into this. This has a company's name, their address up here, I assume would go in, and then it talks about the loss, when it was created. And in Florida, there's different kinds of claims. You have supplemental claims, emergency claims, non-emergency claims. Those aren't always in every state. Supplemental claims, I don't know if that even exists in other states technically. Just a Florida thing. It's for you guys that aren't in Florida. Supplemental claims are usually when you just open an old claim with additional things after it's been settled. You can do that in any state. You call it something specific in Florida. If additional costs occur or are incurred as a result of a loss, even after the claim has been settled, as long as there isn't a full release, you could always reopen those things. Later on in this, they start talking about this public adjuster contract as a public adjuster services agreement. You can't really change. It's either an agreement or a contract. Am I right about this, or is this just not really that big a deal?
It's probably not that big of a deal, though. Even the law uses those two terms interchangeably.
Okay.
So I bet that's probably not an issue.
It does go into the proof of loss thing right here. It says, by signing this, insured agrees and attests under penalty of perjury that the following proof of loss package is true and correct to the best of their knowledge. Insurer understands and acknowledges that pursuant to perjury title code E 837.02 for the state of Florida. Before we got on the air, Tim called this a Franken contract. Is that what you said?
Yeah, it looks like there's been a marriage of different contractual language. Sort of like Frankenstein's monster, because again, you wouldn't typically see a proof of loss in the public adjuster contract connected. That often you would have a public adjuster contract and a proof of loss, but this is the first time I'm seeing them connected, which leads me to believe that perhaps this is something that has been derived of putting a couple of different contracts together.
Yeah, it seems that way. It does feel like this language that I just read out loud is also copy pasted from somewhere else, especially the part where it says the insurer understands and acknowledges. This is not a contract that the insurer signs. So how could a policyholder attest that the insurer has any understanding or knowledge of anything? It's weird. So I think that they meant to delete that in whatever it is that they copy pasted over, and did not delete that. But just so you know, that's there. But if we took that language out, by signing this, the insured agrees and attests under penalty of perjury that the following proof of loss package is true and correct to the best of their knowledge. They are hiring a public adjuster and at the same time attesting that the proof of loss package that must be attached is true and correct.
Yep, that's right.
That doesn't make sense to me. If I'm a PA and I'm doing a contract at all, I probably haven't done the work to be able to present a proof of loss package yet.
I was just thinking about that. How, before you've been under contract, have you been able to do the investigation in your work to be able to provide the proof of loss? I don't know how these things could be done simultaneously.
Yeah, I don't know, but there it is. It goes into the public adjuster's fees and how they're calculated. Public adjuster acts as a public adjuster on behalf of the policyholder for the services provided, and fees will be paid upon the preparation and or presentment of the claim for loss, damage, and recovery for the loss under any insurance policies, including those listed above, related to the following insurance coverage provided in the policies. It sounds like they're saying that the fees will be paid upon the delivery of the presentation of the claim. Does
That's
that mean at
exactly
the
what this
time
is.
of? Yeah.
Yeah.
I don't know if that
And
means at the time of or based on what is being presented, or that's what the consideration for the fees is supposed to be. Maybe it's poorly worded.
Yeah, I mean, your guess is as good as mine. If I'm putting my judge hat on and I'm reading this provision and asking myself, what does it mean? It says the fees will be paid upon the preparation or presentment of the claim for loss, which means that whenever I prepare or present their claim to the carrier, that I should be paid my public adjuster fees. I mean, that's what the plain language says, although I doubt that's what they mean.
Yeah. I mean, who knows though? So it doesn't.
I mean,
really
that'd
make
be a
sense.
great gig, right? Drop $1 million estimate and get paid that day, whether or not the carrier accepted it or not.
I mean, if that's when the fees are supposed to be paid, that does violate most state laws.
Yeah, all of them that I know.
All of them that I know as well. And I say most just because there's probably one that doesn't. So public adjusters are supposed to be paid as money is collected from the carriers.
Yeah. And so this is an instance where there's often this tension in law, like your contract can say anything. It's how you act that is often most important in the eyes of the law. So let's say that this contract says this, but the public adjuster actually only takes his fee upon the recovery, which we know is most state statute. Even though his contract is technically out of bounds of that, he probably is never going to run into trouble as long as he follows whatever that statutory framework is. There's sort of a difference between academically looking at this contract and, what would happen in practice. Now, of course, as a lawyer, I wouldn't recommend this contract, but if I were to pick it up and defend this person, if they did it that right way, maybe they would argue no harm, no foul.
Right. Maybe. I don't know.
I don't.
Okay. So I'll move on from that. If you're going to write a contract, though, and you want it to be accepted by the state, because many states do have to approve. And by the way, the state has not approved this contract, just so you're aware. But if the state is supposed to approve it, they're probably not going to approve it with language like this. Mostly because
they're not. And this is a really good example of, like, it's easy. And I see this online all the time. Hey, does anybody have a contract for X, Y, and Z? You have no idea if somebody sends you one of those, who drafted it, whether it complies with local regulation, whether it's approved by the state, whether it's like this one, perhaps you wouldn't want this language at all. Like the cost to hire an attorney to draft a contract pales in comparison to the cost to hire an attorney to fix the damage that's done after you enter into a bad contract. So if anything, this is a plug for a little bit of payment on the front end to get a professional to take a look at this. Would probably save you a bunch of headaches on the back end. If somebody signed a big, let's say they signed a $50 million condo down in Florida after a hurricane on this thing, and they did all the work and got it all the way there. And then there was an issue. I mean, this contract is probably unenforceable.
Well, so that's been an issue for someone specific that did send it to me, where the policyholder is trying to get out of the contract, and it seems like that's going to happen. And they were reaching out to me trying to find ways to avoid that scenario. And I was the wrong person to reach out to for that. They need an attorney. But it's concerning. It is in a section that says services, and it's trying to describe the services. So I would give the benefit of the doubt to the PA on this one and say that they're trying to describe what services they're going to provide and what it is that they're going to end up getting paid for. But you don't have to have anything about the fees in the services. You can just describe your services, and that would be fine.
That's correct. Yep.
All right. So there is this other section I hadn't highlighted yet. Right here it says other, and it's blank. And I want to ask you, Tim, if you're in a state where the contract has to be approved by the state before it can be used, can you really have a blank anywhere where you can fill in whatever you want?
Maybe not, but this is under the services section. So I'm thinking to myself, is there a world where the public adjuster might be performing some service that's a little bit outside of his norm? Like, let's say he shows up and tarps a window or something, and just because he's there and he's got the construction know-how. So I wouldn't expect to see that in a state approved contract, but I could think of some scenarios where the because this is under the services line, the public adjuster might be rendering some service that's outside the norm of his public adjuster realm. But I think your gut on it is right. That's unusual.
It is. And there's another place where it's more concerning down at the bottom. But yeah, I'll give you that one because it's under the services. They might have additional services to do. I have okay. Someone just posted from U.S. Claims Advisors. I have a copy of Florida's agreement from the state, and the one you're reading is not right. Meaning, I guess it's wrong. Or hopefully, maybe he's saying that the one I'm reading isn't the one that this whatever company this is not using. I don't know. We'll find out. All right, let's talk about assignment here. Assignment of your public adjuster's fees. Getting a public adjuster to be written onto a check is normal in public adjuster contracts. I highlighted this not because I disagree with the language that's in here, but mostly because I wanted to talk about whether this is normal for every state or not. So let me read it for the people that are listening to this. Notice public insurance adjuster services and of assignment. Policyholder further agrees and confirms that a portion of the recovery from any insurance company has been assigned by policyholder to public adjuster. Accordingly, public adjuster has instructed and hereby instructs all insurance companies and authorizes public adjuster to direct all insurance companies to make policyholder and public adjuster co-payees on all payments, checks, and or drafts prepared by insurance companies for claims related to this agreement. And I'll stop reading there. This is fairly normal, but there are laws that talk about there's anti-assignment laws, and most of that is for anti-assignment of benefits, anti-assignment of claim to contractors. Do you think that those same laws could be applied to public adjusters in the future?
Yeah, and I think that they are in some states. I feel like I just read a case about that. So yes, really? And this would be a good instance of whatever state you're in, you have to talk to somebody who's knowledgeable in that state, because this might apply in 49 states, but it doesn't apply in the 50th that you're in. And assignments are a thing that are going sort of by the wayside. You're seeing, like you said, a statutory framework eliminating them. And in some states, I don't believe a public adjuster can take an assignment of the claim. They can have a direction to pay, but that's different than an assignment. So this would be an instance of, if you've got this in your contract, you really need to talk to someone in your state to make sure that's something you can even do in your state. Because if you can't, a portion of this contract is void, which might make the whole thing void.
Yeah, maybe. Whoa, what just happened? I got it back. Just trying out different things here. We'll go with that. All right, so let me get into the next section. It says, this is where it contradicts itself from before. Policyholder agrees all risk and or damage inspections are to be coordinated with and through a public adjuster. A written estimate of the damages for submission as proof of loss must be submitted by the public adjuster within 60 days of the date of this contract. Yeah, earlier it said that this was a proof of loss and that the insured attests under penalty of perjury that they agree to this proof of loss. So either they're agreeing to one that is written in a part of this contract right now, or they might even be agreeing to one that is going to be written in the future before they even see it.
Yeah, the contract up above that we were reading earlier says that it's coming with a proof of loss because they're attesting to basically the attached proof of loss, which is completely an opposite of that provision that you and I just read, that the proof of loss will be forthcoming at a later date, which would be common. The proof of loss always comes after the public adjuster contract. So that's how you can sort of start to smell that these are multiple contracts sort of jammed together. Because those
contract concept,
yeah, those terms can't coexist. They're mutually exclusive of one another, which would be another reason, the person that talked to you, another reason why you might be able to invalidate this contract if you're in court.
Agreed. Here's a thing that's very Florida specific, and maybe it's not Florida actually. I haven't heard this rule for public adjusters. I've heard this rule for insurance companies, but it says a signed contract must be submitted to the insurance company in 30 days of the date of this contract by public adjuster. That's not the part I was talking about. Here it is. 48 hours notice is required to policyholder before any inspections by the public adjuster. This can be waived by agreement. I know that the insurance carrier must give 48-hour notice before showing up, and they have to announce who's going to be there in Florida. That's not true for many states. I wasn't aware that a public adjuster had that requirement. I don't know if you know.
Yeah, I think that there's a couple of states, and I think it from fire chasers, where they've got 48 hours to maybe back out, or and this maybe would be a waiver of that rule. I
So
can't
there's a
remember which state it
cancellation
was.
notice later on in this particular contract that would probably be the different part of that you were suggesting.
Sure.
But
yeah, I'm not too familiar with that rule. I'm sure it exists in one state, and that's the state that this agreement was originally written for.
Right. Yeah. So maybe it might just be wrong. There's a lot of other things that are wrong in here. If you're knocking on a door as a public adjuster and doing an inspection at that time, you definitely have not provided 48-hour notice. And that is allowed in the state of Florida to knock on doors as a public adjuster and perform an inspection. So,
okay.
I don't know. But maybe by them agreeing to it, they're waiving it. I don't know Florida that well. I live there, but I don't know it that well. So I could be wrong in this. If any guys that are watching this right now know for sure, put it in the comments. That'd be great. Policyholder directs the insurance company to provide something within 10 days. And then these are the things that they're requiring: certified copy of the policy, the type and limits of the coverages afforded by each policy. And then this, which I haven't seen before, a statement of any policy or coverage defense that insurer reasonably believes is available to such insurer at the time of filing such statement for each policy. If a public adjuster sends this to the carrier, can they reasonably request every possible defense from the insurer within 10 days?
Well, I'll tell you what, you can ask for a lot of things. I doubt you'll get it. Honestly, there's nothing wrong with asking. And if they tell you maybe this part of the contract is brilliant, and I'm going to start asking for the same thing. But
I was thinking the same thing. It actually is extremely smart, especially if it builds you up for a specific attack later on in litigation. But
what many states have is something that's the opposite of this. Is there is a requirement under most of the Fair Claims Practices Acts that most states adopt, or some version of them, that states that the carrier has to give you reasonable notice of any coverages that are available to you under your policy, which is sort of which is sort of the opposite of this.
Exactly the opposite of this, really. So, if they're going to have, if an insurer doesn't lay claim to a specific defense, then they cannot bring that defense into court after the fact, which is probably what this is trying to set it up for.
Maybe they're trying to say you didn't acknowledge this defense and therefore you've waived it, but that's not going to hold up in court. The defenses can be, that's not going to hold.
I mean, a lot of times
I love the try,
requirements to provide the certified policy in a letter of rep or a public adjuster contract isn't also required by the courts, because it's buried in the middle of these things. Is an insurer required to read every line of a public adjuster contract signed by their clients in order to find it?
And pretty often they wouldn't even get it. Usually you would just submit a notice of representation or something to that effect, without divulging your entire contract, because the terms of your contract are immaterial to the insurance company.
Please note that it is a policyholder's intention to make a claim for loss and or damage related to any replacement cost provisions of the policy of insurance. I've seen a lot of PA contracts with this language in it. Mine even had it in it when I was at All Good for a while, up until the point where I had a claim where the policyholder had no intention of making repairs. And I realized that my contract, or actually it was in my letter of rep, didn't give the option for the policyholder to decide if they were actually going to make a claim for replacement cost benefits or not. And I understand the intention behind this. There's language in policies that state that you have to give notice within a certain period of time that you intend to recover or make repairs or make a claim for replacement cost benefits. And if you don't do that by that deadline, then you waive your right to the replacement cost benefits and your only actual cash value. Even though you didn't specifically state that you were making a claim for actual cash value benefits. But I don't know if it's a good idea to put this in a contract without having something in like an initial portion or something along those lines so the policyholder can make that actual call.
Yeah, and I'm trying to think about how this would actually play out in practice. You're right why it's in there, to prevent those provisions from depriving a policyholder of their replacement cost benefits by failing to announce their intent. But one of two things is going to happen. The policyholder is going to make those repairs, in which case this was accurate, or the policyholder isn't, in which case it's sort of a no harm or harmless error situation. So a checkbox is more accurate because it is actually considering the policyholder's intent, but I don't know that you'd ever see any real ramifications from it, because it's not like the insurance company is going to go, hey, wait, you said you intended to do the repairs. Why don't you do them so I can pay you more money if you just elect to keep your ACV and not do the work? So it would probably end up being a harmless error.
That's true. And that's why that, I never got in trouble for it either. But our letter of rep ended up having an initial section at some point to give them this option. There are times when policyholder decides later on that they're going to change over to only request ACV and move or something along those lines. And sometimes the ACV is worth more than what the RCV might be in really weird scenarios. So there's times when you wouldn't want to make that, but you're right. No carrier.
But I'll tell you what, that initial is smart though, and here's why: is because if there's an initial there, the policyholder is affirmatively electing to place their confirmation on that fact. So think ahead, and you've been in some depositions. If I'm in a deposition with the policyholder and we're fighting about replacement cost benefits, and the carrier's attorney goes, hey, when did you provide us notice of intent? And they go, I don't know. And then they go, well, did you read this contract that said you had notice of intent? They're going to say what most people will say. No, I didn't read that. I didn't know about that. And they're going to kill their claim. If there's an affirmative election there, that deprives that defense completely. It's dead if there's an initial there. So that's actually a better practice in most cases.
It's worked out for us. And even before we had the placement for an initial or checkbox, if you wanted to do that, even before that, we were able to use our letter of rep to point out to those carriers that were trying to deny coverage that we didn't give intent, that our letter of representation or notice of engagement, whatever you want to call it, depending on the state you're in, actually said that the insured intended to make those repairs. And that has led to us getting those additional coverages. But yeah, affirmative action is always better. I got a question from Richard Jizorski. Good friend of mine. He's in Illinois. He says, we are not required to provide our contract in Illinois. They make us.
I think you are in Illinois. Yeah, I think that the carriers are entitled to it in Illinois, but it doesn't matter basically because Illinois' statutory framework is such that the state has to approve your contract. And basically they only approve the state's version of the contract. So it's not like you're out anything by providing the contract. But yeah, I do believe in Illinois, they're entitled to ask for it.
U.S. claims editor says, yes, what I'm saying is the one you're reading from is not the one that I sent from the DOI. I'll be honest, I don't remember because I don't know people's company names a lot of times, and it doesn't have his actual name on there. So I apologize, U.S. claims adjusters. I don't know who you are. I apologize. I have forgotten who I got this specific version of it from, and maybe I'm using the wrong version. For the purposes of this podcast, just go over things. I think it's fine because we're still pointing out some things that are wrong. But if this is a contract that you're using and it has been fixed, then great. I wasn't intending to point out whose contract this was. And honestly, I don't even remember anyway. So if this isn't your contract and I'm getting all this wrong, let me know. Okay, so let's move on. That was the intention part. Any public adjuster or policyholder for the insurance company must immediately send a public adjuster and policyholder any additional or supplemental documentation or information that may be discovered in the future related to this request. I guess this falls into those requests that you might as well ask for it. You're probably not going to get it kind of a thing.
Yeah. Well, and it also assumes that we're now like 3 or 4 pages in to a document that the carrier is likely not reading anyway, that they've read that provision, and certainly they haven't.
This has the cancellation notice, which usually has to be in a certain boldface font or something, or a certain size, depending on what state you're in. There are states that require this to be a separate form. So this one is saying that there's a 10 days after the date of this contract must be provided notice. Let me just read it. Contract or cancellation of agreement. You, the insured, may cancel this contract for any reason without penalty or obligation to you within 10 days after the date of this contract by providing notice to company names submitted in writing and sent by certified mail, return receipt requested, or other form of mailing that provides proof thereof at the address specified in the contract. So I'm going to highlight this real quick. Without penalty or obligation to you. That's going to come into play when it says down here that in the event that they cancel, I think I lost it, that any fees that they had been advanced for the processing of the claim would have to be due to the policyholder, that any expenses would be due to the public adjuster, not the policyholder, even in the event that they cancel. But in this cancellation agreement, it specifies, and this is usually language that is required by the state to say these specific words, without penalty or obligation. Would reimbursement of expenses be a penalty or an obligation of the insured, do you think?
Yeah. Yes, they would be. But most of the time when these states have these cancellation statutes that you have to follow, there's almost always an exception for things that are emergency in nature. And it comes from like emergency board ups, things like that, where people hire a contractor real quick to board up, and then they don't want to work with that contractor, so they cancel the agreement. It's not fair to not allow them to collect what they had to do on an emergency basis. So I would assume that wherever this is, in whichever state it's in, there's going to be an exception for any emergency services or expenses that the public adjuster incurred, emergency board up very likely being one of them.
Okay. I mean, it does go into emergency stuff down here in a completely different size font, which probably should be, because it's still cancellation notice information, probably still should be in boldface font at the right size, but it might be just additional information that's added on. So it says, during any state of emergency as declared by the governor for a period of 1 year after the date of loss, policyholder shall have 10 business days after the date on which this agreement is executed to cancel this agreement. If during the pendency of this agreement, public adjuster determines within its sole discretion that policyholder can no longer be represented for any reason, public adjuster may withdraw from further representation. So this is probably just the ability for the public adjuster to stop being a PA for that person.
Yeah.
If that's not written in a contract, can a
for
public adjuster still cancel the contract?
I believe so. I'm assuming this has a termination provision that allows that. But it would be weird to have that buried into the notice of cancellation provision like it is.
It is. It's weird. All right. Fees for services. This goes on to say what the public adjuster is entitled to. Public adjuster's fee shall be immediately due and payable upon insurance company making any payment, which is the way that most states require public adjuster fees. And it can only be, if it's a contingency based, you can only have contingency for that amount of those checks that are being paid and not the full amount. You can't make due for RCV recovery that's been approved when they've only gotten an ACV payment so far. So this is in contradiction to itself earlier, where it said that it would be paid upon the delivery of the presentation of the claim earlier. But I think that was just miswording of the presentation of the claim earlier.
It was, but this is a contract, so that matters. Right.
So, I mean, we, as public adjusters, we fight contract language. That's part of our job. And so many PAs think they're attorneys and want to be able to say that they can write, contract language, and they really mess up a lot, and it's unfortunate. But
yeah, well, I mean, we've got the reciprocal problem. There's a lot of attorneys who think they're PAs. So
that might be a different episode.
You know who you are. But the reality is, we've been at this for half an hour, and we've identified no less than like 25 things that are fatally wrong with this contract. But, if you picked up this contract, it's paginated like you would expect. It's got bold provisions and the provisions that you would expect. It's got the headings that you would expect. If you didn't spend any time looking at this and you just picked it up and didn't really pay attention, it sure looks and feels like a regular PA contract, but it's anything but that once you get down into it, which is why without any question, especially if you're a public adjuster, you have to start this at an attorney's office. It can't be that you got it from your buddy on Facebook who posts a lot about claims. It can't. That even if it's a great contract, it still might not marry into the state that you're in. And that's what we're seeing here is this wouldn't work in a lot of states, even if all of the other things we were talking about is cleaned up. And it doesn't cost that much to have an attorney review a contract to get it right.
Yeah. So moral of the story, guys, you should not be trying to write your own contracts or adding into a contract without the help of an attorney or at least someone to sign off on some of this stuff that's really going to look at this. If you guys attempted to take a look at these contracts the way that you're looking at the policies and getting into the nitty gritty of it, you should be aware that if your contract isn't solid, then the policyholder is going to possibly be able to get out of paying you. So you're in business to make money. Although, interestingly enough, they're only allowed to work in the best interest of the policyholder alone. So if the policyholder wants out of their contract, they have to act in their best interest. Would they even be able to pay fees if you're actually acting only in the interest of the policyholder? That's a different argument, I guess.
I mean, it's an interesting philosophical question, but I think the
yeah.
Fiduciary duties that you describe are in the course of carrying out your contractual duties, not that you have to do all things that would be good for the policyholder, like give them your car and, all of those other things.
It could cause some problems. All right, I'm gonna back up on this one and read a little bit more because that was the normal stuff. So let's talk about these fees real quick. Fees for services. Policyholder understands and agrees that public adjuster shall recover its fees based on the amount recovered from an insurance company for the loss, including but not limiting to compromise, confession of liability, appraisal awards, judgments, awards and or settlements of damages, costs, interest, fees, and or payments of policyholders' liens, bills, or claims. Now, I've never done work in Texas where interest is common. Do public adjusters usually take percentage of their fees on interest?
No, and I'm not sure that they could in most states because most states it's limited to their recovery from the carrier or under their policy. It's limited to the recovery under the policy.
Sure.
And interest is never really a creature of policy. It's almost always a creature of statute. So that would be one of those rights I would suggest probably exists outside of this contract. Fees would be the same thing. If we're talking about attorney's fees, sometimes in court, if there's a bad faith case, the policyholder could recover their attorney's fees, but it would be unusual to see a public adjuster get a piece of that. That has nothing to do with their work, really. That's a statutory scheme.
I didn't even catch that. That's a solid point because it is recovered from the insurance company in the event of a lawsuit. If you're in a state where the attorney's fees would be paid by the carrier in a bad faith situation. Yeah, it does sound like that's what they're trying to say. Maybe it isn't. But
no, I think what they're usually when we talk about attorney's fees, we say attorney's fees. So probably what this means is referring to any fees the insured might incur that are reimbursable under the policy. Like a reboarding fee or some sort of fee to move if there is a fire. And I would expect that the public adjuster would recover a portion of that. But you wouldn't if it was court fees that you might recover in court or interest that you might recover from court. And no state that I work in could I think of a public adjuster having an actual potential interest in those things if it didn't come from the policy.
Yeah. Bills is interesting. I mean, I don't know many PAs that would actually charge fees on getting them reimbursed for excess electric bills or something along those lines. But
yeah, I don't either. So this is an interesting question that I have for you, Matt, that I've debated with many people.
Sure.
What is your take on once a claim goes legal, if it started with you as the public adjuster and then it had to be taken over by counsel, should your fee still be calculated on whatever resulting judgment or settlement we get? Do you have a feeling about that?
I do. I believe that it's going to be a case-by-case basis. I want to give you a blanket statement of yes, but there are times when the PA has done nothing, right? And now it's with an attorney because time has expired and they need to get it in before a deadline. And then the attorney ends up hiring other experts to end up doing the job that the public adjuster did. In those cases, I don't think it's reasonable for the public adjuster to expect to get their fees. But in many cases, the public adjuster has done all of the legwork, has teed it up pretty nicely for an attorney, because if they do that, they usually end up winning the case without the attorney anyway. And now that it's in the attorney's hands and the attorney ends up getting the approval, I think that the public adjuster in those cases should be awarded their fees. Now, how do you designate when one is the other?
Yeah, and I don't think you do. And I appreciate your thoughtfulness on that, because you're right. There's some instances where a public adjuster may have literally done nothing. And I'm thinking about those guys that, call them what you will, they're bird dogs for attorneys. They don't do anything on the claim other than find it, sign it up, and hand it to an attorney and then hope they get it paid. I would suggest that they shouldn't. But in almost every situation that I'm involved in, the public adjuster has done some groundwork. And the reason it didn't get paid is because the insurance company did something that the public adjuster didn't have the legal license to hold them to task on, right? That only I could do because of my special ability to go argue in front of court. And I don't even understand the argument that people would make that you wouldn't be entitled to your cut of the fees in that situation, because but for you, there wouldn't be that situation. So I hear a lot of people go, once you turn it over, then there shouldn't be any fees. It's like, well, I don't agree with that, really, as a matter of principle.
So let me turn this back upon you. Same question, but backwards. If an attorney takes on a file that the public adjuster has already basically done everything on, and the only thing that you really have to do is file suit and have a few conversations, should the public adjuster's fees come out of your fees since they did most of your job?
That's an interesting question. And I would say not, because even though they did some of the things that I would have done, we still served separate roles in the claim. But I can tell you, the days of me picking up a file and making a phone call or two and getting it paid are becoming less and less. But when they do happen, I would say myself and just about any other reputable first party firm that you know of, they're not going to charge their full rip in that case. They're not. They're going to make up for it by charging a reduced fee, which is something we do all the time.
You know, and PAs end up doing that as well in order to make sure that the policyholder is able to actually make repairs. I have had so many calls from Remington where he's like, hey, can you take a lower percentage of your fees on this one? The insured is going to be out of pocket X amount of dollars otherwise. And we've always reduced our fees in those cases. We don't want to put policyholders in a position where they can't make repairs just because we had to get an attorney involved. And in so many states where the attorney's fees don't get paid by the carrier, you know, you end up making those kinds of concessions. So we don't want it to go to attorney because we don't want to reduce our fees and we don't want it to take forever.
Yeah, I totally understand.
Yeah. Richard says, yes, as the public insurance adjuster, provided that you did all the work, proof of loss, photo reports, measurements, scope estimate, and attempted to present a claim following the duties after a loss. So if you've done the job, he believes that the public adjuster should get awarded those fees.
Yeah, I think we're in agreement of that.
What if the public adjuster submitted a proof of loss for $100,000 and then it got in your hands as an attorney and you were awarded $200,000 because once you got a different expert involved, the amount of loss was increased because of something that the public adjuster didn't do?
That's a tough one. I think we're talking about what would be probably a super exception in the world. But if we're talking Tim and Matt are just making the rules of when somebody should get paid, I think they'd probably be capped at their 100 in that scenario.
Yeah, I think so too. All right. Or should be anyway, whether or not that actually ends up applying that way or not. I think that becomes a conversation between the attorney, the policyholder, and the public adjuster to determine what's fair at that point.
Yeah, that's exactly right. And, you know, we're talking big time about a contract here today, but that shouldn't give way to this sort of common sense discussion that you and I are talking about right now when we're, you know, in the thick of it. and we're trying to figure out a resolution that suits the policyholder, and we're trying to get to yes with the carrier. Just because my contract says I could get 1/3 of the damages in that situation doesn't mean that that's right for every situation.
Right.
You know, it's okay to give a little to make sure that the policyholder is taken care of. Not in every case, right? We're in business as well. But there are certainly situations where common sense has to give way to the contract.
I'm with you on that. All right, so let's get back into this thing. I'm going to skip over the rest of the public adjuster fee stuff, even though there's a few different fun things in there, including another blank other space for the fees, which I think would probably not be a good thing to have in there if you're trying to get your public adjuster contract approved by the state.
Yeah, agreed.
So let's get into the expenses. There's an interesting thing in here on that. If policyholder authorizes in writing public adjuster to pay on policyholder's behalf such costs and expenses that the public adjuster deems necessary from time to time to investigate, prepare a claim, settle a claim, and or take other action the public adjuster deems necessary to pursue policyholder's claim, policyholder understands such costs and expenses advanced by public adjuster on policyholder's behalf are payable to public adjuster and shall be deducted from any recovery after fees for services are computed and paid to public adjuster. Basically, it sounds like the public adjuster gets to unilaterally determine what additional expenses are going to be required. Now, I don't know about Florida, but most states that I'm aware of would require the public adjuster to identify what those expenses would be before incurring those expenses.
Yeah, I totally agree. This is a section, if you had it in your agreement, you'd want to change. It makes sense that you don't run everything by the policyholder. So if I wrote this, or if I rewrote it, I would say the policyholder authorizes anything up to $500 that you believe is necessary to do the claim, because that's a matter of things being expeditious and not waiting on approval for tiny things. But in excess of that, you would want the policyholder's agreement because you don't want them to come back and argue with you about an expense that they wouldn't have believed needed to be incurred. It's just good for them to have their approval on those things if eventually they're going to be their obligation. And having it this way, I would argue in a lot of states would make this contract void, because that is an unlimited arrangement to act with discretion. I mean, they could incur $1 million fee on a $10 loss. That's void as a matter of public policy, in my opinion.
Absolutely. I can tell you this, just to play COIA as a public adjuster, you should be getting these kinds of approvals in writing too. Or on a recorded call if you're in a state where you can do that kind of a thing. These are contested items usually. And what I've had in my contract in the past, and I don't know if this is appropriate for every state, but in the state of Georgia, I had a few contracts that were different. I had some for roof-related claims, and for the roof-related claims, I had common expenses that I did on every single one. So in my contract, I specified ones that I was going to have on every claim already so that they could go ahead and initial off on it, including like an Eagle View. Yep. I think that might have been the only one for that particular contract for the roof-related stuff. So I had that expense already written in there because it was common. I was going to have it on all of them. There was no question about it. And that way I had that out of the way. I didn't have to worry about getting it taken care of later on. I'm being petty at this point, but it says that the public adjuster may have a lien or a claim for quantum merit. And there's supposed to be a U in there.
There is.
For that to be the proper Latin term, which basically just means, a fair amount, a fair sum. Anyway, I'm being petty. Spell stuff right in contracts, guys.
Well, especially that thing, because you're right. Quantum merit is a pat on the back. Hey, man, you did a great job. That was a meritorious thing that you did. That was quantifiably meritorious.
Yeah, very different thing. All right, so now we have this letter of protection thing, which I've never seen in a public adjuster contract before. And it might be brilliant. It might not be. There's some things in here that make me nervous. I'm going to read this out because it's interesting. Policyholder understands and agrees that if it becomes necessary to retain an attorney, policyholder authorizes and agrees to a letter of protection. An attachment to this contract would be one of these letters of protection. For the public adjuster, policyholder shall direct policyholder's attorney to prepare a letter of protection, which is a legally binding document signed by the parties and the attorney that directs policyholder's attorney to pay the fees and costs due under this agreement from any recovery by policyholder for the loss. This is basically saying that policyholder agrees to direct whatever attorney they hire to fill out this form so that the attorney is required to pay the public adjuster's fees in the event that they go into litigation. You ever seen that before?
I never have. I understand why you would put this in there because I've never seen it happen, but I hear of people at conferences, oh, the attorney never paid my bill, which I guess anything is possible, but our professional rules are pretty clear on that. So if that happened to you, that's a professional. Yeah, it's a professional violation. This contract already says you have a lien for the work. This is completely superfluous. You don't need it. And I don't think most attorneys would do that either.
But public adjusters, if this is a contract for their work, they want to protect their services and their fees. I can understand why someone would want that. It's not going to be anything that would stop this contract from being legal, probably. Policyholder agrees that this agreement constitutes a lien against any recovery proceeds paid by any insurance carrier or from whom or from whatever source, settlement, judgment, or verdict, which may be paid to my attorney or myself. So this is where it changes over from saying policyholder agrees to my attorney agrees or myself as a result of the above claim. I agree. Company name has a lien on any recovery up to the amount of the PIA contract signed by me. If I feel like a public adjuster that had this contract mostly looked over by an attorney, decided they wanted to add a sentence in and then didn't even keep the same format.
Yeah, it's problematic.
Yeah. All right, let's get into some of the ugly stuff. If an attorney must be retained, public adjuster, which we're saying company name, will have provided all the necessary components to successfully pursue an insurer for proper indemnification to that attorney. Is that always true?
No, in fact, it is never true. Because I mean, if you had to turn it over to an attorney, you necessarily didn't provide everything that was successful for proper indemnification. So no, you wouldn't want this in your contract. It creates a standard you can't even live up to. You would just delete it entirely.
There's bound to be something you missed, right?
There has to be.
Or could be argued that should be necessary.
Yeah.
Obviously, you didn't do enough.
Contracting 101. Never set
pursued.
such a high standard for yourself that you can't meet it.
Right. You should say the opposite. The company will not have provided all this and you'd be fine. Don't do that. The insurer acknowledges and agrees that public adjuster will retain an indisputable 10% ownership of this claim. I don't know what to make of that line.
Well, it's gibberish, and I think that's why it's hard to understand. I guess that's trying to relate to the assignment of benefits they took earlier, but in this very paragraph, they're taking a lien of 10%, which is something akin to ownership.
Well,
but now I guess they have straight up ownership.
Fees, and the fees were supposed to be written in their blank lines. So it's not necessarily always 10%. So this one was probably copy pasted from another contract, maybe from Texas or somewhere that has a 10% fee cap. But can a public adjuster have ownership of any portion of a claim?
I don't know. I mean, I guess under the assignment of benefits theory, possibly, if we're getting like hyper academic, possibly, but
maybe
I wouldn't want that language in my contract.
I think the lien establishes what you'd be due in the event of an attorney anyway. You wouldn't need this. All right. So this is the part that I don't like about this thing the most. After the public adjuster has performed the claim, proven the damages, and yet the insurer does not pay, an attorney is sometimes necessary. When this occurs and an attorney would accept the claim on contingency and the policyholder chooses not to proceed anyway, public adjuster will still be owed their fee.
No, they won't.
You can
It's
only
a fun
charge a
thing to
fee on
say,
what's
but no, they
covered.
won't.
No.
Yeah.
You, just because you write
Well,
this in a contract doesn't mean that it's okay.
yeah. And I suppose that what they're trying to say here, and I think what you take offense to, as do I, is that they would still be owed their fee on whatever estimate they prepared. That would be untrue. But they would still be owed their fee on anything that got paid. That would still be true.
Okay. You know, I didn't even read that. I read it my way only. That's
You read it
ambiguous
your
there.
way because
So
that's what they meant.
I
I
think
read
that's
it
what
the
they
other way
meant.
as a
Yeah.
kindness to this person who's got a pretty terrible contract.
It feels like it wants to force them into hiring an attorney and doing it by saying that you're still going to owe my full fee for
Yeah,
whatever that
it
amount
does feel
is.
that way, and that's how it's written. And actually, even if an attorney was taking this on, you'd want to be careful. I don't want my clients entering my engagement under duress, which I think you could argue this would be.
Yeah. All right. I'm glad you read it differently though, because you could argue that at least. Yeah. Okay. So here's some other stuff. Provisions concerning services. Policyholder and public adjuster understand and agree that neither party shall settle any claim arising out of the loss without first obtaining the consent of the other. Does an insured ever have the obligation to get consent from a public adjuster before settling their own loss?
Negative.
I didn't think so either.
I understand why the provision's there, though. You don't want the insured accepting $10 if you know you could get 50. But
Right.
I do not believe that would be enforceable in any state that I can think of.
It's just almost like a bullying tactic.
Yeah, I was. That's a good word. I was going to say it's a little distasteful as well, but yes, bullying would be a good word.
The next sentence is horrible. Policyholders' deposit or negotiation of a claim payment is evidence of policyholders' consent to settlement.
Don't think that's accurate either.
So the unfair claim settlement practices doesn't allow an insurance company to put on a loss draft that this is a full and final settlement and actually have that hold weight. Just because they deposit a check doesn't mean that the policyholder is agreeing to a full and final settlement in any way. And yet this public adjuster contract is saying that.
Yeah, and I don't even know why you would want that in your contract. I don't see the benefit to the public adjuster.
I don't either. If the policyholder deposits a check, then I guess this allows the public adjuster not to go and get consent from the policyholder.
Yeah, I guess, but man, you'd be in a whole lot of trouble with any of the state regulators I know if you did that.
If a public adjuster were to say, I'm done negotiating this claim and the policyholder wants you to get more, this could potentially be a way of saying, well, you deposited the check, you must have agreed to it.
Yeah, and it could be a way that the carrier could go with that because this isn't the carrier's
Carrier
words.
would want that for sure. Yeah.
Yeah.
I've known public adjusters that get involved, do very little, take their 10% of what the insurance company likely would have approved anyway, and not want to negotiate any more beyond that point, and try to tell a policyholder, this is a fair and reasonable settlement. I think that we should settle here. And when the policyholder disagrees, what is a public adjuster supposed to do? They can withdraw at that point and charge on what's been approved so far. But I've seen public adjusters try to convince the policyholder to accept that settlement amount. And if this is one way of just saying that you did accept that amount so that you don't have to have that whole argument, you could still just cancel at that point and charge what you would have up to that point and let them hire somebody else, though.
Yep, totally agree. It's a weird provision.
Blows my mind. I think it violates the unfair claim settlement practices. Does a public adjuster have to abide by those?
Not usually.
There was a bill I read, and this is why I even thought about it. There was a bill I read earlier today, and I think it was Delaware. Delaware might actually have that in the laws, or it was in a bill that was passed.
Yeah, not in any of the states that I operate in that I can think of, although I'm not often thinking about that question either.
Yeah.
So maybe they do.
I mean, it's still
but most states have public adjuster statutes, and that's what defines their behavior and their conduct.
Okay, so there's a lot of other stuff in here. Policyholder agrees to cooperate with public adjuster to be available for preparation of the claim. Policyholder acknowledges the public adjuster has made no guarantees. That's good. This agreement provides a complete and only agreement between policyholder and public adjuster with respect to the above referenced loss, and supersedes all written, oral, prior written and oral offers, proposals, and agreements. I'm going to skip down. This agreement shall not be construed more strictly against public adjuster simply because it was the party responsible for preparing this agreement. What would happen if insurance companies wrote that into a policy?
Yeah. This is kind of an interesting academic area of law. So the rule of contract, and all of you public adjusters should know it, is that if a provision can be read more than one way, it's construed against the drafter. The drafter usually being the insurance company and the policy. Here, it's the public adjuster. So there has been a movement in modern contract drafting that a lot of people will write this in so they can avoid that rule, that it's not going to be construed against them. But you can only do that in an arm's length transaction where you and I are negotiating. That's not what happened here at all. So this is an adhesion contract. It's a take it or leave it contract. That would never hold up in court. If there was a contrary provision in here, it would absolutely be construed against the public adjuster. Now you can put it in there.
Is this still a contract of adhesion if it's got those blank spaces available for someone to write something in and then no one does?
That's a fair question. Maybe, maybe not. Even if it wasn't, there's no court in the world that would enforce that provision. Yeah. There's no way.
I thought it was interesting. I wanted to ask you if an insurance company put this in their policy, if it would be enforceable.
It wouldn't, and they can't in most states. Most states wouldn't allow that.
Right. Right. What about a surplus lines?
Maybe. Maybe. I still think it would be void as a matter of public policy, though.
I mean, they still have to abide by contract law.
Yeah.
Yeah. But they could put it in there and see what happens, I'm sure.
Yeah, well, I mean, the fact of the matter is it's an interpretation rule that it would be construed against the drafter. If that's just not the default, now maybe the court has a little more leeway to look at the provision and to figure out what it means. I guess that could still possibly be fair.
All right. Policyholder understands and agrees that policyholder will need to enter into a separate agreement, a separate written agreement with an attorney of his or her choice, and make separate payment for such services provided for representation. Will need to enter into, not. Now, I read that out of context, so it's not fair, but out of context, that sounds like you're requiring the policyholder to hire an attorney.
Well, and it sets a terrible expectation that you're going to need one, and maybe you won't. Like I would argue that the whole point of getting a PA is to avoid the necessity to get an attorney involved at the outset. So it's just not thoughtful. Whoever wrote it, again, wasn't thinking about the business implications. It should say, in the event policyholder needs an attorney, we understand that they would have to enter into a separate written agreement because we don't provide legal services. That's what it should say, but that's not what it does say.
It probably doesn't even need to say it.
It doesn't.
I mean, you're not stating that you're providing legal services anywhere in the contract. So do you have to state that you're not providing it?
No, but I know why they do, because every now and then, if somebody is trying to get out of their PA contract, a clever lawyer is going to go, you acted like a lawyer, and therefore your agreement is void because you're not one. So that's why this is in there. It's for protection against that. What's that?
I would love to see a lawsuit against a public adjuster for acting as an attorney that actually stuck.
Yeah, I've never seen one, but I've heard the argument.
We hear it's a bully tactic from carriers oftentimes. Correct. Or their counsel just trying to scare you off of something.
Yep.
I've never seen it stick. So to be fair to this PA agreement, the next sentence says public adjuster encourages policyholder to seek appropriate legal services if necessary. So even though that statement was problematic before, where it seems like they're requiring you to have a separate agreement with an attorney, it does say only if necessary in the next line. But anyway, all right. And then here's a whole nother blank section. Policyholders, exceptions, changes, input, or modifications to this agreement. I don't see any state approving a contract that has something like this in it.
Me neither. And frankly, I don't know why you would put it in there and invite exceptions and modifications to your contract. Certainly if the policyholder asks for them, but like if you put in a blank space like this, you're like telling somebody, hey, find some things you want to change in here. And now you're going to spend time dickering over terms that may or may not matter. If somebody's writing this contract, if I'm writing it for a client, I would never put this in here.
Yeah, no, it's a problem. In the signature line, it requires the policyholder's date of birth and place of birth. Are there states that require that? I don't know.
None that I know of. Date of birth, I could see maybe somebody like a carrier might need that to identify an insured. But place of birth is a weird one.
It is weird. It's very weird. And then the public adjuster signature doesn't have a line for their email address, which a lot of states require. Outside of that, this is very long. It's very generic, but it's got some problems in it. I hope this was helpful for any of you PAs that are out there that are trying to have a valid contract. The moral of the story is to get an attorney that has a valid contract that can sign off on it. There are things in this. Use your PA skills to see if there's anything that you catch the attorney missed and ask the attorney about it. But yeah, not the greatest thing in the world. So
not even close to the worst one I've seen though.
Seriously?
Oh, not even close. No.
Wow. Yeah. There's certain parts of that I found more concerning than any that I've seen before, especially the parts where it says that by signing this check, you are agreeing to the settlement, or that the public adjuster has to agree to settlement. They were concerning, but is what it is. So real quick, if you guys have been watching through this entire thing about contracts, good for you. You're as nerdy as I am. Tim was very nervous about this being an episode that not many people watched. And considering how many of you are watching this live right now, he might have been right. I think this will end up being an episode that people will go back and watch several times, though, and become more important down the road. So I appreciate you hanging in there with us. Talk about my sponsors real quick. Inc. Payments is a company that can handle your insurance company payments. When the loss drafts come through, they can handle getting the endorsements and electronic signatures on things. If it is a monitored claim, it might still take some time and have some additional things involved, but you can keep track of all that stuff a lot better using Inc. Payments than trying to figure it out for yourself. They've already figured out what all of the stuff is going on with all the mortgage companies. They know that stuff inside and out. That's what they do for a living. If you're interested in working with them, great guys. Go to inc.com. Go to inc.com/signups even, and you could use promo code BULL to get a special discount on your first check endorsement as well. Promo code BULL. Claim Titan is a PA CRM. If you are a public adjuster and you're using a CRM, such as Claim Wizard, Claim Titan is an alternative that is fantastic. Building Experts Institute is an online school that I happen to be a part of. We are dropping Xactimate certification courses, levels 1, 2, and 3 this month. You can access those. They are pre-recorded. Go at your own pace. And it's part of the membership for $109 a month. You can't get Xactimate training cheaper than that. And you also get all the other courses that are on there at the same price. You don't have to pay additional for each one. It's all part of that same $109 a month membership. Go to buildingexperts.institute for that. If you're a roofer, Hook Agency can handle stuff. I'm not going to talk much about them on this one because this was really a PA show. American Policyholder Association, the PAs know about that. Huggins Law Firm in the states of Georgia and Florida. That's Remington, my normal co-host for this. And that's enough of that. Tim, what is the name of your company? How do people get a hold of you?
Smith Jaden Johnson. Obviously, they can find us on all of the social media under Smith Jaden Johnson or SJJ Law. And of course, you're welcome to call me 952-314-1169.
Perfect. If you guys have any questions or anything about what's been on this episode, put them in the commentary wherever it is that you're at. I'll try to get to them. If Tim can't, I'll try to find someone to get on there or sick Holly Soffer on these if necessary. But I think there's going to be a lot of comments on this particular episode, probably years from now as people are still watching this. But thanks for hanging in there with us, doing a really nerdy thing. And I'll see you guys next Tuesday. Thanks a lot, Tim.
Bye, y'all.